Hey everyone, what's up? And welcome back to CraigTrader. It's great to have you here for another video where we break down complex financial topics and make them easy to understand. Today, we're diving into something incredibly important that often gets overlooked: estate planning. That's right, we're talking about making sure your hard-earned money and assets end up exactly where you want them to be, whether it be with your family, a charitable cause, or anywhere else you decide. Now, before we get started, don't forget to hit that thumbs up button. Subscribe to the channel if you haven't already, and click the notification bell so you never miss an upload. And for those of you who want to take your investing game to the next level, make sure to check out the link in the description for our free newsletter. We're all about helping you achieve financial freedom, and that includes protecting what you've worked so hard for. So let's get right into it. First up on our estate planning checklist is creating a will. I know, it sounds a little morbid, right? But trust me, it's one of the most important documents you'll ever create. A will is essentially a legal document that outlines your wishes for how your assets should be distributed after you're gone. Think of it like giving your money and possessions a roadmap, so your loved ones don't have to fight over them, or even worse, end up in court battling it out. Without a will, your estate is subject to the laws of intestacy, which means the courts will decide who gets what based on your state's specific rules. And let me tell you, those rules might not align with your wishes at all. So to avoid any confusion, potential family feuds, and ensure your wishes are honored, creating a will is absolutely crucial. Now you might be thinking, Graham, I'm young. I don't need a will yet, right? Well, the truth is, it doesn't matter if you're 25 or 65. If you have assets, you need a will. And by assets, I don't just mean millions of dollars in the bank. Your assets include everything from your car and your savings account to your furniture, electronics, and even that vintage Pokemon card collection you've been holding on to. Having a will ensures that all of these things, no matter how big or small, are distributed according to your wishes. Plus, a will lets you name a guardian for your minor children, which is arguably the most important reason to have one. If something were to happen to you and your partner, you want to make sure your children are taken care of by someone you trust implicitly. Don't wait until it's too late. Take the time to create a will now, and have peace of mind knowing your loved ones are protected. Alright, so now that you understand the importance of having a will, let's talk about how to actually create one. You have a few options here. First, you can hire an estate planning attorney to draft a will for you. This is generally the most expensive option, but it can be worthwhile if you have a complex estate or specific wishes that require legal expertise. Second, you can use an online will-making service. These services are typically much more affordable than hiring an attorney and can be a great option for those with simpler estates. And lastly, you can even find DIY will kits online or at some office supply stores. However, I'd caution against this option unless your situation is extremely straightforward. No matter which method you choose, the most important thing is to have a legally valid will in place. Moving on to our next estate planning essential: establishing a trust. Now, trusts often sound more complicated than they actually are, so let's break it down. In simple terms, a trust is a legal entity that holds and manages assets for the benefit of someone else, known as the beneficiary. Think of it like a safe deposit box for your assets, but instead of you holding the key, a trustee you designate manages the contents according to your instructions. There are various types of trusts, each designed for specific purposes, but they all share the common goal of providing control, protection, and potentially some tax benefits for your assets. Now, you might be asking, Graham, do I really need a trust? Isn't a will enough? Well, the answer, as always, depends on your individual circumstances. Let's dive into some common types of trusts and why you might consider one. A living trust, for example, allows you to manage your assets while you're alive and seamlessly transfer them to your beneficiaries after you're gone, potentially avoiding probate court altogether. Then there are testamentary trusts, which are created through your will and only become active after your death. These are great for providing for your loved ones over time or for specific purposes, like funding a child's education. Trusts can also offer creditor protection, minimize estate taxes, and even provide for loved ones with special needs. They offer a level of control and flexibility that a will simply cannot match. Ultimately, deciding whether a trust is right for you depends on your financial situation, your family dynamics, and your long-term goals. If you do decide to establish a trust, choosing the right trustee is absolutely crucial. This person or institution will be responsible for managing your assets and carrying out your wishes as outlined in the trust document. You can choose a trusted family member or friend to act as your trustee, but it's essential to consider their financial acumen, their ability to make impartial decisions, and their willingness to take on this significant responsibility. Alternatively, you can appoint a professional trustee such as a bank or trust company. While this option typically comes with fees, it offers experience, impartiality, and a level of accountability that can be invaluable. Remember, establishing a trust is a significant decision, so it's essential to consult with an estate planning attorney to determine the best course of action for your specific situation. Let's talk about something equally important: designating your beneficiaries. It doesn't matter how well you've crafted your will if you haven't clearly designated who receives your assets. Think of beneficiaries like the designated drivers for your assets. You're handing them the keys and saying, "This is yours when I'm gone." It's crucial to be specific here. Review these designations regularly, especially after major life events. Not designating beneficiaries can lead to unintended consequences and legal battles. Now, when it comes to choosing your beneficiaries, you have a lot of flexibility. It could be your spouse, your children, other family members, friends, or even charities that are close to your heart. You're in the driver's seat here. It's also important to consider contingent beneficiaries. These are your backup drivers, the ones who would inherit your assets if your primary beneficiary is unable to, for whatever reason. This ensures that your estate plan is covered in any eventuality. Another thing to keep in mind is that you can designate different beneficiaries for different assets. You might leave your house to your children, your retirement accounts to your spouse, and a portion of your savings to a charity you support. The key takeaway here is that designating beneficiaries is not a one-size-fits-all situation. It requires careful thought and consideration to ensure that your assets end up in the right hands. Okay, so you've put in the work, you've designated your beneficiaries, and you feel good. But here's the thing. Estate planning isn't a set-it-and-forget-it kind of deal. Life is constantly changing, and your estate plan needs to keep up. Make it a habit to review your beneficiary designations every year or two, or whenever a major life event occurs. Got married? Had a child? Went through a divorce? Any of these events could warrant an update to your beneficiaries. And don't forget to communicate with your beneficiaries. Let them know they've been designated and where to find important documents. Trust me, this will save them a lot of stress and hassle down the line. Remember, taking the time to properly designate and update your beneficiaries is a priceless gift you can give your loved ones. It provides peace of mind, knowing that your legacy is in order, and your assets will be taken care of according to your wishes. All right, so we've covered wills, trusts, and beneficiaries. But there's another crucial aspect of estate planning that many people overlook, and that's taxes. Just like your income, your estate can be taxed at both federal and state levels. These estate taxes can significantly reduce your assets. The good news is, with careful planning, you can minimize or avoid these taxes. It's essential to know the estate tax rules and exemptions in your state. For example, in 2023, the federal estate tax exemption is over $12 million. Estates valued below this won't owe federal estate taxes. However, some states have their own estate taxes with lower exemption limits. Consulting with a qualified estate planning attorney or tax advisor is crucial. Professional advice will be well worth it in the long run. Let's talk about smart strategies to reduce your estate tax burden. One effective approach is lifetime gifts. The IRS allows you to gift a certain amount annually without incurring gift taxes. For 2023, that amount is $17,000 per recipient. Start gifting money annually to reduce your taxable estate. Another tool is setting up an irrevocable trust. Transfer assets out of your taxable estate with potential tax advantages. Estate planning maximizes asset value for future generations. Finally, remember that estate planning is not a one-time event. Tax laws, your financial situation, and your personal circumstances can change over time. It's like managing your investment portfolio. You wouldn't just set it and forget it, right? You need to rebalance it periodically to align with your goals and market conditions. Similarly, it's essential to review and update your estate plan every few years, or whenever there's a significant life event, such as a marriage, divorce, birth, death, or a substantial change in your assets. This ensures that your plan remains current and effective in achieving your wishes. Think of it this way. You spend years building your wealth, so don't let taxes erode it after you're gone. By being proactive and staying informed, you can leave a lasting legacy for your loved ones and minimize the impact of estate taxes. Now, let's talk about a topic that many people would rather avoid: long-term care. It's not the most exciting subject, but it's crucial to address, especially as you get older. Long-term care refers to the assistance you might need with daily activities like bathing, dressing, or eating if you become unable to do them yourself due to aging, illness, or disability. Now you might be thinking, Graham, this doesn't sound like a big deal. But trust me, the costs associated with long-term care can be staggering. We're talking about tens of thousands, even hundreds of thousands of dollars per year, depending on the level of care needed and where you live. These costs can quickly deplete your savings, putting a strain on your loved ones and jeopardizing their financial future. It's like having a major unexpected expense, like a sudden roof repair on your rental property, but on a much larger scale. That's why incorporating long-term care planning into your overall estate plan is essential. By being prepared, you can protect your assets, safeguard your independence, and ensure that you receive the care you need without burdening your family. So, how do you plan for long-term care? Well, there are several options to consider. One option is self-insuring, which means setting aside a portion of your savings specifically to cover potential long-term care expenses. This approach gives you greater control over your funds, but it requires significant savings, especially if you anticipate needing care for an extended period. It's like having a large emergency fund for your investments. You're prepared for the unexpected, but it requires discipline and careful planning. Another option is long-term care insurance. These policies are designed to cover the costs of long-term care services, providing you with financial peace of mind. Premiums for these policies vary depending on factors like your age, health, and the level of coverage you choose. Think of it as an insurance policy for your real estate investments. It protects you from potential financial losses due to unforeseen circumstances. Regardless of which option you choose, It's essential to integrate long-term care planning into your overall estate plan. This includes discussing your wishes for care with your loved ones, appointing a durable power of attorney for health care, and potentially establishing a trust that can help manage your assets and cover care expenses if needed. Remember, estate planning is not just about what happens to your assets after you're gone, but also about ensuring your well-being and protecting your family's financial security while you're alive. By addressing long-term care in your estate plan, you're taking a proactive step to safeguard your future and provide peace of mind for yourself and your loved ones. It's like having a solid property management team in place. They take care of the day-to-day operations, allowing you to focus on the bigger picture. So there you have it, a comprehensive guide to the top strategies for complete estate planning. Remember, estate planning is not a one-size-fits-all endeavor. Tailor these strategies to your specific circumstances and goals. By taking control of your estate plan, you're protecting your assets and ensuring your legacy. If you found this video helpful, hit that thumbs up button and subscribe for more financial tips. Don't forget to hit the notification bell so you don't miss out on any future videos.